All right. We want to record it for the benefit of those who also registered. Many of them did register, but are not here and they will receive the recording. All right, guys. Welcome, welcome, welcome. Thank you everyone for joining us today. This is one of our Friday firesides um, of the Foreign Born Military Spouse Network. I will be your host today. My name is Lydia Witio-Tiena. I am the founder and CEO of the Foreign Born Military Spouse Network, where our mission is to connect, support, and empower foreign born military spouses just like you and I. I know you're not used to me hosting these, but today Fadwa is not here and I am taking over. Okay? Welcome me warmly. Thank you. Allow me to share a little bit about who we are and why this space exists. So, the Foreign Born Military Spouse Network was born in response to the experiences of spouses like us who bring incredible strength, talent, and resilience to our military families, but many face unique challenges such as navigating immigration and legal systems, overcoming employment barriers, adjusting to military culture, and often doing it all far away from their native country and support systems. We exist because too many foreign-born spouses are quietly struggling. They are highly educated but underemployed. They are fluent in many languages but feel so unheard. They are caregivers, volunteers, and leaders in their community but often invisible in national conversations about military families. Now, FMSN is here to change that. We provide training, resources, we provide training, resources, mentorship, advocacy, and most importantly, a community, a place to be seen, supported, and empowered. Our goal is to ensure that every foreign-born spouse can thrive economically, emotionally, and professionally, no matter where their journey begins. So thank you for being part of this space. We'd like for you to join us in building something powerful together. Quick housekeeping for everyone. If you'd like to ask some questions, feel free to drop them in the chat or send them to info if you'd like. But we will have an opportunity for you to do that at the end of our presentation today. We are 16 minutes in, still waiting. Jesse, could you check with the attorney, please?
Ye- She just sent me a message saying that she had just parked, so she should be there. She should be joining us any minute soon.
Awesome. I don't want to do her a welcome when she's not here.
I appreciate your patience and I apologize for this.
It's okay.
I'll say she's well worth the wait.
Okay. Yeah, I know. I've spoken to her before and yeah. And also probably let's talk a little bit about her as we wait for her because she might not get the chance to say a lot of everything that she does. I just want to be able to read a little bit about her. She's a highly respected immigration attorney with over 18 years of experience in private practice. She's also the founder of, do we say Roife or Roife Law Group? She has dedicated her career to helping individuals and families to navigate the complexities of the U.S. immigration system with a deep understanding of the challenges that immigrants face. She has become a trusted advocate for clients seeking to change. Hold on, I'm gonna have to admit other people in doing double work here. Um, Tisan, I'm gonna make you co-host so you can admit other people. Okay, thank you. This is the hiccups when you're not used to hosting that much. Yeah. She has become a trusted advocate for clients seeking to achieve legal security and unite with their loved ones, build bright futures in the US. She was born in Russia, so she's also foreign born like you and I. Her journey is truly international. She was raised in Israel and completed a high school education in Canada before earning a bachelor's degree in Montreal. She received a JD from William Mitchell College in Minnesota in 2008. Her diverse cultural background has shaped her empathetic approach to immigration law, giving her a personal understanding of the unique struggles faced by immigrants. So we are definitely in good hands. Her professional accomplishments are vast. She has served as a local ICE liaison for the American Immigration Lawyer Association, famously known as ILA. So you can see it's someone who has a lot of ins and outs for over a decade and continues to collaborate closely with officials and chief counsel both locally in the Twin Cities and nationwide. This position has provided her with unparalleled insight into how government policies and philosophies shape immigration outcomes in real-world scenarios. In addition to her legal expertise, she is a recognized thought leader in immigration law. She has been featured in the Star Tribune, partnered with WCCO for public commentary on immigration issues, and has delivered presentations at numerous ILA and federal conferences across the country. Her ability to articulate the complexities of immigration law makes her a sought-after speaker and trusted resource in the legal community. At Roife Law Group, she leads a multilingual team fluent in Russian, French, Hebrew, Arabic, and Spanish, ensuring that clients receive personalized and accessible services. The firm specializes in family-based immigration, deportation defense, asylum applications, business visas, citizenship, and more. She is deeply committed to creating tailored legal strategies that account for each client's unique circumstances, providing guidance at every step of the process. When she's not advocating for clients, Nadezda remains active in legal education and public policy discussions, using her platform to champion the rights of immigrants and shed light on the human impact of immigration policies. We will share a link in the chat for the group. I will
She
also
just sent,
share it. Oh,
I'm sorry to interrupt. She sent a message saying that she was waiting to be admitted.
okay. Maybe my co-host did not see her. I've sent a link in the chat. We will also share it in the after email when we are sending the recording and everything. So don't worry if you don't find it there.
And there she is.
There
Good
she.
morning, good afternoon, or good evening to some of you.
Hi, thank you
Hi.
for coming on.
Terribly sorry for this god-awful delay. The day already with court and appearances kind of got derailed, but I'm here. I'm more than happy to assist. I'm ready to go.
Thank you. So I've just done the introduction, read your whole bio as we were passing time. So I
Great.
think you can just dive right in.
All right, wonderful. Well, nice to meet all of you, and I appreciate everyone's patience. I think the purpose in our conversation today with your wonderful, I want to call them staff or liaisons that have created the seminar. The purpose of the seminar is to educate all of you about the basics of the U.S. immigration system. As we all know from reading the news, if you're here in the United States or if you're abroad, we find ourselves in a very unprecedented, very difficult. I hate to use the word very lawless time, which is very unfortunate when it comes to the role that you and your significant others, your spouses serve for into this country. Our background, and I'm sure Jesse shared with you a little bit, but our background comes from also, I come from a military family myself. I grew up with strong military values. The military was Soviet Union, then we lived in Israel for an extended amount of time. So to see how things are currently is very challenging for all of us. Nonetheless, there are three essential pathways to have somebody get immigrated or have somebody immigrate to the United States. Those three essential pathways are still very basic. You can move to the United States and stay here permanently on what's called a humanitarian basis. That is the asylum, the refugee repatriation status, other humanitarian bases such as an informant, a government aid. I have a lot of clients that do a lot of very high-end informant work or government aid work. So that's one pathway. The second pathway is what's called an employment-based pathway. That is where an employer sponsor and it could actually be anybody within any branch of the U.S. government, the U.S. military as well, sponsor you to move to the United States. And the last one is the family-based unification. So that is the what we call the family-based migration or the family-based chain migration to move to the United States. For the purposes of this presentation, I'm only going to focus on the family-based. If any of you have any questions about either the humanitarian-based or the family-based basis, please let me know, and I'd be more than happy to develop and dwell into that section. But for the purposes of our chat today, we're going to be focusing on what's called the family-based immigration. I'm going to break it down.
Interrupt. Do you have
Please.
a presentation? I'm happy to give you rights to.
Yeah, to share anything. No, I didn't put a PowerPoint for the purposes of today. I'll just be talking. And I should have asked this before I started the presentation. How do we want to do questions? Do we want to save questions towards the end, or do we want to interject with questions?
We will do it at the end. We will turn off recording because some might be sensitive questions. So once you're done with the presentation, then we turn off recording and people are free to ask questions.
Sure. And just remind me, Lydia, I have about 30 minutes, correct?
Yes.
Okay, very good. I'll be mindful of that. Us lawyers like to talk, to hear the sound of our own voice, for the lack of a better term. Okay. On the family-based immigration, I'm going to split the conversation into two pieces. I'm going to first start focusing on the family members that are abroad. So if your family members is not in the United States, I'm going to explain to you what are our rights and what can that family member do for you to immigrate them to the United States. And then I'm going to move into the family members that find themselves in the United States in various different statuses, be it legal, undocumented, semi-documented, and we'll talk about that aspect. So for those of you that are stationed abroad, that have happened to, met somebody abroad and fallen in love with somebody that is in an international place in a different country, what is it that you can do for them? Well, if you're not yet married and you're considering marriage and you are a U.S. citizen, then the next step is to consider a fiancé visa. A fiancé visa is, it does what it sounds like. A fiancé visa is available if you have met your foreign national fiancé face-to-face in the last 2 years, and if you yourself are free to marry that person and they are free to marry you. In other words, all of their other cultural or religious marriages or civil marriages have been resolved. There's a lot of confusion about those. I've worked a lot with individuals from West Africa that don't understand what is a religious marriage versus a cultural marriage versus a civil marriage. There's a lot of countries in Southeast Asia that also blend those two together. So if you're confused about what is a legal marriage, what is a cultural marriage, please let me know. I'll be happy to explain that. But or divorce, same for divorces. So if that individual and you are free to be combined in a marital union and you're not yet married and you'd like to bring this person to the United States as soon as possible so that they can conclude their immigration process in the US, you can file a fiancé visa for them. Fiancé visa requires that you're in a bona fide relationship, that you're in a relationship that is going to lead to marriage. And upon the approval of the fiancé visa for your fiancé at the US consulate abroad, that fiancé is free to enter the United States, and within 3 months of them entering the United States, marry you and file for their green card. So the requirements are that you're a US citizen, that you've met your fiancé face-to-face in the last 2 years, and that both of you are free to marry and are in a bona fide relationship with each other. Process is rather smooth. You submit a petition to Homeland Security, USCIS, I'm going to call it internal immigration, alleging all of those factors, alleging that you love this person, that you've seen them face-to-face, that you're free to marry, and that you're in a bona fide relationship. The government would like to see evidence of your relationship. The government is still very dated and old school. They really like paper. So they're going to want to see your communication. If you chat on WhatsApp, the WhatsApp chat history, same on Facebook. If you're chatting in any other kind of means, something that is more or less, controlled by the government, just ask for permission to export those chats if you're chatting on any kind of a controlled app. But then, photographs. The government loves photographs. You can submit photographs and then petition Homeland Security to permit your fiancé to come to the US. The US government will receive the petition, acknowledge it. They will send you a receipt It's an 8x11 regular piece of paper that says we've acknowledged the receipt of your case and we'll start processing it. Current processing times for what I call the internal immigration case for a fiancé visa is about 5 to 8 months. After that, the US government will take the file and move it to the Department of State. The Department of State is the agency that is responsible for consulates, for US agencies abroad. And the Department of State will go ahead and process the case for your fiancé to be interviewed. There'll be more forms to fill out. The fiancé will always have to undergo a medical exam. The US government is still very protective of the health aspect of foreign nationals that are moving to the US. They're going to want to see vaccination. Most often vaccination. They also do a chest x-ray to make sure you don't have, the fiancé doesn't have an active tuberculosis outbreak, and then process them for the interview, where at the interview they'll ask them a lot of questions about how you met, how you've stayed in a relationship, how have you been together. Once that occurs, the US government will place what's called a sticker visa in their passport. It will be a little fiancé visa in their passport. The fiancé will be able to then come into the United States and fulfill their intent to marry you within 90 days. And then from the United States, you will be putting together an application for your fiance's green card once they've married you. In a case such as yours, where a lot of you are in active duty stationed abroad, I wouldn't be surprised if the fiancé visa is decided much sooner. I wouldn't be surprised if the US government will blitz through your case and the US consulate will prioritize your interview in a much shorter duration of time than, roughly speaking, about a year and a half. And why is that? Because the US government still has a strong relationship, the US Department of Homeland Security, with the Department of Defense, confirming that we should really process our military spouses and our military personnel that are on active duty much faster and kind of prioritize them and put them ahead of everybody else. So what if you're already married and let's say your wife or your husband are in the Philippines, in Sweden, in Manila, Philippines, Manila, in Sudan or whatever, then the process is actually very similar. You would submit a petition to immigrate your foreign national spouse to the United States and request that the US government approve the same thing, that you're now married to each other, not that you're free to marry, but that you're married, that essentially you were free to marry, that you've concluded your other relationships in the past, and that you are intending to be together in good faith. The US Homeland Security Department on the internal side will approve your petition much faster than the traditional 1 year that they wait on the petitions for everybody else who's not on active duty. On the 1 year requirement, I would say probably the government will try to expedite your cases and approve them as quickly as about a month and a half to 2 months. So that's really nice. After that, your fiancé will also be required to work in us with the Department of State. So internal Homeland Security government finishes the file, transfers it over to the Department of State. The Department of State receives the file and starts working on the file and seeing the documents, all of the information, the medical, the clearance letter that your fiancé doesn't have any criminal history in the country where they're from or any other country where they lived after the age of 16 for at least 6 months, and then summon your spouse for an interview. Provided the interview goes well, sticker visa, and they come into the United States with an actual green card. So the sticker visa will serve as a green card versus the fiancé visa. The sticker visa serves as a temporary non-immigrant visa to come into the US and essentially become an immigrant in the United States, a green card holder. For both of those cases, folks, the US government likes to ask a lot of questions. A lot of questions that are very, I would say, Americanized in nature. A lot of questions that some spouses don't necessarily talk about, such as finances. How do you spend your money? What do you spend your money on? How do you earn your money? Where do you earn your money at? When it comes to residence, because most of you, if you're stationed abroad, you are with your spouse, the US government might require that while that occurs, that you are either working on securing residence in the United States or that you can show that there's some sort of permanent domicile in the United States. The US government is slightly confused when it comes to military spouses, and we need to remind them this all the time about you being stationed abroad, of what's called the immigrant intent. both on the fiancé visa and on the spousal visa. The law, in the spirit of the law, says, hey, if your foreign spouse from abroad is going to come to the United States, you, the U.S. citizen petitioner, that's what we call in the law, the requestor, need to have your feet standing on U.S. soil for that petition to be approved. Otherwise, the permanent resident request is uncertain. Are you really, for a national fiance or spouse, going to be a permanent resident of the US, or are you just going to kind of sort of come and go? When it comes to the military spouses, it's extremely important to include your charging documents, your even as simple as military ID, and your orders that you're stationed somewhere else to make sure that the consulate understands this situation and doesn't require that your foreign-born spouse has to prove that you, the person serving abroad, needs to be in the US. So that's a very important component not to miss. Another thing, financials. For every single immigrant green card, the US government wants to see proof that if your fiance or your foreign national spouse immigrates to the United States, they will not become what's called a public charge. A public charge is food stamp recipient. So the US government is very worried about being a food stamp recipient. The US government will want to see, proof of income from who? From you. It's a very strange, what I call a three-way contract, where the US government says, hey, show to me your finances so that if your spouse needs benefits, if for some reason they receive them, if the benefits, if the government wants them back, and if the spouse cannot pay, we're going to try to collect from you. For the rest of the country and the rest of everybody else that is applying for their fiance, the poverty guidelines, the requirement for financials is set 100%, 125% above what's called the poverty threshold. The 125% above the poverty threshold is said to be very, very low. It is dependent on the cost of living in terms of the cost of food. It does not include the cost of housing. So for example, for a household of two, I always round it up. If it's just you and your fiance or your husband or wife to be, you need to earn about $25,000 a year. For a household of three, the fee goes up to about 30, so forth and so on. However, for military spouses, the fee is quite substantially lower. And it is lower because we understand in the US government that you are serving our country. And of course, your remuneration and compensation tends to be quite a lot lower because of the fact that you're serving on active duty. And the US government is taking care of such a huge vast of your needs, and is just paying you a very low percentage per diem. So be mindful of the fact that if you don't introduce your papers that you are stationed or that you are in active duty, then the US government will require you to be subject to the higher bar when it comes to finances. And the US government will be in error, in my opinion, about your financial situation, because you're required only to prove what's called 100% of poverty guidelines. So you need to be able to show the 100% versus the rest are required to show 125% of the poverty guidelines. Those are the two options to bring your foreign-born spouse to the United States. You can either bring them as a fiance, or you can marry the person abroad and bring them to the United States as a green card holder. After they enter the United States and they receive their benefits, after they enter the United States and they receive their green card, there are restrictions on how much can the foreign national spouse travel without authorization. The restrictions are that your foreign national spouse with a green card cannot leave the country for more than 6 months. However, there are requests and permissions that your foreign national spouse can request when you are stationed abroad. So if, for example, you are processing your foreign national spouse, you're going to be in Fairfax, Virginia for a period of 6 months, but after that, you understand that you're going to be deployed to Qatar. And the US government is saying, all right, this is where we're sending you. You're going to be there for an extended period of time, where you're thinking, my gosh, what am I going to do? I just immigrated my foreign national spouse to the US. They have a green card. I heard a lawyer on a webinar discuss the fact that they cannot stay abroad for more than 6 months. What do I do? Request the travel document. It's called a reentry permit. It's a permit that will permit your foreign national spouse with their green card and that document to stay abroad for a period of up to 2 years. Remember that that permit is a single entry, single use document. That means that with that permit, your foreign national spouse can leave, but if they come back, they invalidate the permit during the pendency of those 2 years. Do I agree with the logic of the US government when it comes to these permits? No, it makes no sense why that is so restrictive and why it's so difficult. But if they know that they're going to stay out of the United States and they do not need to enter the United States for any reason whatsoever for a period of over 6 months, my recommendation is to get that permit. The issuance time is fairly complex. In some cases, we see an issuance time as quick as a couple months. On some, the issuance time is ridiculously long, about a year. Your foreign national spouse is only required to do their biometrics, their fingerprints. If they're in the United States, they will go through what's called a fingerprint process, and then they're welcome to depart and be stationed with you while the document is in process and pending. So if there's any other questions about that, I'd be more than happy to assist you with those questions. So that's if your fiance or your foreign national spouse is abroad. To recap, you can bring them here in a fiance visa, show the government that you're in a bona fide relationship, intending to marry this person. They will go through a consular interview somewhere abroad, receive the visa, come into the US, marry you, and do the green card process here. The other way to do that is to have your married or to marry them abroad and then petition for them to basically immigrate to the US as a green card holder. All right, those are the two ways to bring them from abroad. Well, what are the ways to help your foreign national spouse if they are already in the United States? The answer is very much so depends. Depends how their immigration history or how their immigration process commenced when they were what's called inspected and admitted to the US. Almost everything in the Immigration and Nationality Act, as it relates to benefits to either immigrate to the United States or become some sort of non-immigrant in the United States. What do I mean by non-immigrant? Some sort of a worker, some sort of a student, some sort of a, exchange student worker, some sort of a journalist, some sort of extraordinary ability, performer or educator. Depends on what is the immigration history. So what we do in our career, whenever we see individuals that have a spouse that is in the United States, my first question is, let's discuss about your travel and immigration history to the United States. If you were inspected and admitted anytime at all in your life, and that was the one and only entry that you used to come to the United States. Example, if in 2005 you entered the United States from abroad as a student, and you had now remained in the United States on that non-immigrant visa, if in 2015 you entered the United States as an exchange worker, and you stayed in the United States as an exchange worker, if in 2017 you entered the United States as a visitor and you had remained in the United States, you as a foreign-born spouse married to a US citizen, doesn't have to be a service person, as a US citizen, you can petition currently in the United States for your green card through your US citizen spouse. You do not need to leave, go to the consulate, start any kind of abroad processes, because the law says, Section 245A of the Immigration Nationality Act says that if your foreign-born spouse crossed the border at any point and what was called inspected and admitted, an officer looked at their visa, read it, talked to them, and let them pass, that person can get a green card through you, irrespective of your service, by virtue of you being a US citizen in a bona fide relationship in the United States. Section 245A of the Immigration Nationality Act forgives all unlawful presence and all unlawful employment. Pretty good gig. So if any of you are married to individuals who came to the US, inspected or admitted, let's talk, because it's a very easy solution. The benefit of you being a service person or on active duty or in any branch of the US military is the fact that the case will go much faster than the usual timelines. The case will probably fly through the immigration system, and thereafter both you and your spouse will always be summoned for an interview. The US government will always want to rule out the nature of your relationship, ask you questions about your relationship, how you met, how do you live together, so forth and so on. And then also about your foreign national spouse's immigration history. How did they come into the US? How many times? So forth and so on. So that's one way to be able to get a green card for your foreign national spouse if they are here on a visa overstay. What do we do for those that are not here with a visa? What do we do if your spouse is truly what we call undocumented? If your spouse is somewhere down the lineage in their immigration history, crossed the border with their family as a young child or as a baby, kind of what we call in tow in somebody's arms, and there's no record of them coming into the United States, of what if they entered the United States completely 100% absent any documents? What if there's zero record of any inspection or admission of your spouse in the United States? And that happens a lot. We have a lot of individuals that are, what we call undocumented. The government tends to call them illegal aliens, individuals that are here without inspection. Well, on that end, we still also have hope and faith and some relief to individuals of that nature. And as I've shared with Lydia, and Jesse knows this, these are one of my most favorite cases to work on, and that is what's called the military parole in place. What on earth is a military parole in place? The Department of Defense and the Department of Homeland Security combined kind of their thinking caps and their thinking forces because of the vast volume of complaints that were being received from from U.S. servicemen that were married to foreign individuals or foreign-born individuals that were not documented. And the grave concern was not only in light of the fact that I'm serving the country and I'm doing my civic duty, being in the U.S. military, I'm worried about not only my contribution, but I'm worried about my family. What does happen if there is an ICE enforcement? What does happen if for some reason we do drive very close to the border and Customs and Border Patrol stops us? What does happen if we are required to fly to Guam, which is, as we all know, a U.S. territory with a very large U.S. military presence, but then for some reason we also are encountered with any kind of inspection? I'm very worried about my spouse. And the Department of Defense and the Department of Homeland Security came to an agreement that said that if you are serving in any branch of the U.S. Armed Forces, you are about to serve or you have served, and you have family members, spouses, children that are interested in immigrating, or parents, if you're if you're serving in the United States and you'd like to immigrate your spouse, your child, or your parent to the United States, and if those individuals, the people that you're interested in immigrating, are undocumented, request a permission to essentially convert them from a ghost, an undocumented person, to a real individual. How do we do that? Very simply, we submit a statement from that person about their immigration history to see that there have not been many violations of the law, coming and going frequently without any inspection or admission, God forbid deportations in the past, anything that what's called would trigger anything else. So if their only accident in their immigration process is the accident by which they got themselves to the United States, or they were brought to the United States against their will as they were children, please disclose that in the statement. Please introduce evidence of relationship, that you're either married, you as the serviceman, either married, or that they're your parents or your children. You introduce birth certificates. Please introduce evidence of their relationship. And then please introduce evidence of your service. Again, folks, as simple as a military ID will suffice. And write to the U.S. government, Department of Homeland Security, a request for admitting, for permitting, for converting your foreign national undocumented spouse into a real person. The request is free. The form is very straightforward. The form, ironically, is being used by the U.S. government for many other purposes. Travel document, request to re-enter the document I spoke to you about, that permits people to come and go from the United States on a green card. But that document is also applicable for individuals requesting this conversion. The U.S. government won't interview you for that application. There's nothing to ask them. Is this your spouse? Are you in the military? Is this the truth that you wrote in your statement? So there's no interview. Eventually, when the document is approved, and our processing time here, ironically, even though all of you are on active duty, is about the same, about a year to a year and a couple of months, and any local offices that would be processing this in immigration on the immigration end anywhere in the country. Request for that foreign spouse to be converted from a ghost to a real person. Once that request is approved, what tends to happen is either your attorney or you will get a ping, will get an email, or even a phone call sometimes from Homeland Security asking your foreign spouse to present themselves for Homeland Security with a photograph and the actual form that they submitted, and the US government will issue to them an I-94. It's a record that creates their lawful admission to the United States. As I discussed earlier, in order to naturalize, in order to make your foreign-born spouse's green card eligible and then proceed to citizenship, those individuals need to be what's called inspected and admitted to the U.S. That document, that parole in place approval, serves as their record of admission and creates a record of admission for them. The entire time that they have been here before undocumented is essentially waived for them. And then the section that I mentioned, 245A of the Immigration Nationality Act, then forgives or waives any other improprieties when they have been admitted to the United States through this document, through that I-94. With the document, the next step, within literally days or weeks, we file an application for a green card for your foreign-born spouse. And then that application will get expeditedly served, will have received priority, and then you will be summoned for an interview to talk to the US government about your relationship with your spouse, and then your spouse will talk to the US government about their application for their green card. Some individuals ask me, sometimes I'm worried about what did they ask in the application for the green card? What should I, be mindful of? And this is both for individuals that are coming from abroad to individuals that are in the United States that are seeking a green card. What should I be worried about? Basic kind of allegiance, national security, public safety questions are the questions that get asked on the green card form. Things such as registering for voting, voting unlawfully, ever falsely claiming to be a United States citizen, engaging in any kind of espionage, activities that are counter to the United States interest, military service. That's a big thing that comes up with my spouses that have a military background that tend to marry other individuals in the military background. The United States government is interested in understanding what their involvement in the military was and if they were ever in open combat. As we've seen now in the heightened processing of the Afghan nationals that were assisting the US Armed Forces in Afghanistan for an extended period of time, the most important things that the government is curious about is they're very curious about any kind of active combat and open combat. The government will literally ask anybody that's been on active duty that's foreign born if they've ever carried a weapon, if they've ever shot at somebody that didn't fire at them first, and just explain and list out their duties and their military duties. I've assisted individuals that were very highly ranked. I've assisted individuals that were regular soldiers that are, clerical work or cleaning duties or some sort of guard duties. So the most important thing is to disclose, declare, not to be fearful. For those of you that have married or have been or worked with or stationed in China or Cuba, I believe we don't have a military presence in Cuba, but China and Cuba or any other countries that are communist or tend to behave communist-like in nature, please do not be alarmed if your foreign-born spouse was either in the military or was a member of the Communist Party. A lot of my military spouses do ask that question because of the commitment in their relationship with China, and their foreign national spouses were in the Communist Party. Provided that the service or the membership in the Communist Party was not voluntary, that it was mandatory to get promoted to the next level of their service, to get advanced in their job or career duties, to get to a different place, or if the service was essentially mandatory for school age and for as you're going through into high school and post-secondary education, that is waived. So please do not be alarmed if your foreign-born spouses have served or have had connections or membership to the Communist Party. That is waived. So don't be alarmed. Don't be alarmed at that. So the parole in place, again, very important thing to utilize. So if your foreign national spouse is here with some sort of a visa, albeit be it an expired visa, a very dated visa, or still a very current visa, they're eligible for a green card. And if your foreign national spouse that is in the United States is not documented, they've never had a visa, and they've come into the United States one time, somewhere down the history of their immigration life. They've come to the United States one time and they are not documented. They're what I call a ghost. You can help them. The military parole in place is still available. Act on it now before the U.S. government changes their policies and tries to deactivate that parole in place, and let's get those spouses onto permanent residency. The last thing I want to touch on, and then I'll open up the floor for some questions, is the benefit of citizenship. Right now, a lot of my clients are asking me, well, Nadia, truly, is there a benefit to citizenship? We're seeing a lot of news about citizenship being re-examined, people being considered for denaturalization. There's a bill introduced as late as yesterday through the news of potentially denouncing individuals that are dual citizens, and I'll explain what that is, from continuing their path of being dual citizens. So should I really become a US citizen, considering the fact that, my God, I could lose my other citizenship, be it British citizenship, Canadian citizenship, Sierra Leone citizenship, whatever other citizenship that I can, should I continue in my pathway to become a citizen? And my resounding answer, nonetheless, with everything that's been going on in our country currently, is yes, absolutely yes. Your family members should absolutely finish their immigration process to the United States and secure their place in the United States. If there are any laws to be invoked retroactively and they were to lose their other citizenship, everybody has lawsuits and litigation rights. We have, still a semi-functioning Supreme Court in the United States that potentially that whole concept will be challenged. The issue that I'm speaking about is that currently the United States law permits an individual that is not born on US soil to hold dual citizenship. What that means is that if your foreign spouse is from Canada and the foreign spouse becomes a US citizen, they are permitted to keep both their Canadian citizenship and also become a US citizen through naturalization. The concept for children maybe gets a little bit more muddy. So, for example, your foreign-born spouse in Canada also has your child in Canada. They both live in Ontario, and you're interested in moving them with you to Florida, for example. So the foreign-born child is a de facto US citizen if they were born to you in your relationship and you've been a citizen when they were born for more than 5 years. So with children, it gets maybe a little bit more tricky. I'm not going to get in on that because it's a very complicated kind of nerdy immigration part of the law. But for you, are you at risk of losing your second citizenship? Again, my reminder to all of you is that despite the strange lawlessness that we have going on in our country right now, there's still rights, there's still Supreme Courts, there's still litigation rights, and most likely if that law was to ever get proposed, it will get heavily scrutinized and there will be many lawsuits for that. But you should conclude your immigration process. You should absolutely become a US citizen for the sake of being done. It is much easier to erode, amend, and change the laws as it relates to non-immigrants. To permanent resident non-immigrants, not citizens, than it is to citizens. Citizenship also gives you a peace of mind. You really are done with the process. The only requirement is that for you to continuously renew your US passport if you are to be traveling abroad. When it comes to certain benefits, God forbid death benefits, but we do need to touch on that. Death benefits are important because unlike everybody else in the US economy, your death benefits could be very, very, very good. The payout, I hate to say it like this, could be very, very hefty. And there are certain death benefits and certain benefits that are not payable under the US law when it comes to permanent residents that are payable to citizens. Number one. Number two, the freedom of travel, the freedom of being able to go to a foreign country and live in a foreign country is definitely something that's within the scope of citizenship. The benefit of collecting retirement anywhere in the world that you'd like. When you're a permanent resident and you decide to move to a different country and collect and retire there based on your earnings in the United States and your spouse's earnings in the United States, if you're a citizen, those benefits are 100%, provided that you're not in North Korea, Iran, areas that we don't have a diplomatic relationship with, that you will have a difficult time collecting your benefits there, collecting your retirement benefits and all the other pension benefits that are entitled to you from the US government is easy and it's guaranteed versus permanent residents have to jump through hoops. And I just think the peace of mind of knowing that your immigration process, your immigration case is truly over and that you possess a US passport is a huge benefit, in my opinion. Despite everything that we have going on politically, internally, in my professional opinion, the US passport is still the best passport to travel internationally when it comes to ability to access countries, when it comes to protection, and when it comes to being able to access the US consulate for, God forbid, any issues that could have happened if you're abroad or getting the protection of the US government. As a matter of fact, a lot of my permanent resident clients that receive permanent residency, if they're still in the serving age, enlist in the US military and become US citizens through their service. So yes, they should all become citizens, and that's a good thing. So to recap, for those of you that have foreign-born spouses that are outside of the United States, we have two options. Bring them to the United States as your fiance or bring them to the United States as your spouse. For those of you that have spouses in the United States, look at their background and how they were inspected and admitted. How did they get into the United States? If they got to the United States with any kind of visa, most likely you and I can work on getting them a green card. If they got into the United States absent a visa and they are a ghost, we can convert them from a ghost to a real person and then apply for their permanent residency. If any of you need to travel when you have permanent resident spouses, you're welcome to travel with them if they request a travel document. And then, yes, everybody should still apply for citizenship. It's a pretty straightforward process. It's not that tedious. If any of you, by the way, have any spouses that are disabled, that are having issues with memory, with cognition, with language, there is a medical waiver available. Talk to me about the medical waiver and I can assist with a medical waiver if they have any memory problems. And short of that, they should all become US citizens. The process is not that difficult and it's very rewarding. Lydia, I will stop right here. And if you would like, I would be more than happy to open up the floor for questions. And anybody can kind of, I suppose, unmute themselves and ask any kind of questions that you may have. I don't know if Lydia, you're still there. I think she may have stepped away.
I'm here. Sorry.
There you go. Okay, no
I
problem.
had my kid call me from school. You know, you just always have to pick those. So I'll
Yes,
try to
of
figure
course,
out if there's anything happening. My apologies.
of
She's
course.
bugging me. I will pick that later. So I want thank you so much for opening the space, for sharing with us all the information. I'm sure many of us here have found it very, very useful. So foreign-born spouses, this is your time for Q&A. I'm gonna go ahead and stop recording because we don't want some of your questions to be heard outside for privacy. And someone asked, is this being recorded? Yes, we have recorded it. We will share it as usual to those who registered and also on the platform so that people can ask questions. That's where most of the interactions happens anyway with the recording. So I'm gonna go ahead and stop recording. Please, if you want to share your question, raise your hand or put it in the chat. Either way, we are gonna get to you.